The tenants celebrated way too early. Broker fees are back, at least temporarily. The Real Estate Board of New York and the New York State Association of Realtors just took the Department of State to court. That was fast. It hasn't even been a week since they issued the guidance stating that if a broker is representing the landlord, they can't collect a broker's fee from the tenants. Today, a New York State judge has issued a temporary restraining order against that ban. I can see why. This was a vicious case of domestic violence. A restraining order was in order. The brokers got slapped in the face so hard they couldn't even go back to work. For many realtors, the broker fee was what was bringing home the bread. That was pretty much their salary. They needed it to feed their families. So they had to fight back. In the petition filed by the Real Estate Board of New York and the New York State Association of Realtors stated that the guidance wreaked havoc on the industry. The lawsuit stated that the Department of State interpreted the law in an unlawful, erroneous, and arbitrary manner. In a statement, Rebney and Nisar said they're looking forward to seeing the Department of State in court in the following weeks. So for now, tenants are still stuck paying the broker's fee. Realtors are allowed to go back to doing business how they used to, without fear of disciplinary action from the Department of State. So was their interpretation really unlawful, erroneous, and arbitrary? So let's take a look at the law itself. So the section that the Department of State was referencing reads like this: except in instances where statutes or regulations provide for a payment, fee, or charge, no landlord, lessor, sublessor, or grantor may demand any payment, fee, or charge for processing, review, or acceptance of an application, or demand any other payment, fee, or charge before or at the beginning of the tenancy, except background checks and credit checks. So to me, it seems pretty cut and dry that it states the landlord can't charge a broker's fee. But where it becomes confusing is, can the broker charge the broker's fee? Because technically the broker is not the landlord. But on the other hand, the broker represents the landlord. So the confusion lies there. So if the broker is representing the landlord, can the broker collect the fee? That is the argument. So personally, I think the broker and the landlord are two separate things. Even if the broker is representing the landlord, they don't have the same powers as the landlord. If you have a lease agreement, the landlord can sign the lease agreement, but the broker can't sign the lease agreement unless the landlord gives the broker the power of attorney stating that they can sign for the landlord. If that's the case and you have to give the tenant a lease, shouldn't the landlord and the broker be two separate things? And in a lot of forms, such as the lead paint disclosure form, where you have to tell the tenant if you have knowledge of lead paint in the house or not, and if you have any records of lead paint, it clearly has a space where the landlord or lessor has to sign and the agent has to sign. So it really doesn't make sense that brokers and landlords are considered two different entities for part of the transaction, and then for the second part of the transaction, they're now seen as the same thing, right? Doesn't make sense. You need to be consistent the whole way through. But I think at the end of the day, the costs are still going to be pushed onto the tenants. So either way, it shouldn't make too much of a difference. Since landlords are just going to push the fee back onto the tenants through added rent, this law won't really make much of a difference. The only people who will benefit from this law are people who are in rent-controlled or rent-stabilized buildings right now, because the landlords can't raise the rents on them to compensate for the broker's fee. The other group of people that will benefit are the people who don't have enough saved up to pay the broker's fee, the first month's rent, as well as the deposit to move out. I'm not against this new law outright because a lot of it actually makes sense. A landlord legally has to give the tenant a walkthrough when they move in and when they move out. That means that when they walk through the property with the tenant when they move in, the tenant can point out what's already broken. And then when they give them a walkthrough when they're leaving, the landlord can point out what's broken and tell the tenant what they're going to charge them for. The landlord can't evict the tenant just because they complained about the condition of something. That makes total sense. If the tenant requests, the landlord has to give them a receipt that they accepted the rent. That makes sense. The landlord needs to send the tenant via certified mail if they haven't received the rent for the month. I mean, that kind of makes sense, kind of doesn't make sense. I mean, I do understand that things get lost in the mail, but on the other hand, I don't think the landlord should have to send certified mail to the tenant stating that they never received the rent. This rule seems kind of archaic because in a couple years, people aren't going to be paying with checks anymore. I mean, even now, most of my tenants pay me via Zelle, so it's so much easier. They can instantly send me a payment online and there's a record of it, so no one can say they didn't receive it or the check got lost in the mail. The landlords can no longer charge a late fee more than $50 or 5% of the rent. This one can be because tenants shouldn't be paying late anyway, right? You should always pay your rent on time. And something happens and you don't pay, the landlord should get some sort of compensation because the landlord needs to pay the mortgage. And if the landlord doesn't pay the mortgage, they're gonna get a late fee for that too, right? If the state wants to limit how much a tenant needs to pay as a late fee, then they should also tell the banks how much they can charge for a late fee if the owner doesn't pay the mortgage because one of the tenants didn't pay. A landlord must now make reasonable effort to rent out the apartment instead of charging the tenant who breaks the lease for leaving early. I mean, most landlords already did that too, but putting it in writing doesn't hurt. The new law states a landlord cannot reject a tenant if the tenant is going to court with the previous landlord or if they've been foreclosed on. This one is a little, I don't know, too much, I think. If a new potential tenant was foreclosed on, that means their finances might not be in the right place. Not allowing a landlord to reject that application, that's kind of bad. Or if they weren't paying rent to the previous landlord, you can't reject their application for that. That's a bit ridiculous. They also extended the time a landlord needs to wait before they can serve eviction papers to the tenants. So now a landlord needs to give 14 days written notice before they can start a court case against a tenant. This might not seem like a lot, but most landlords don't serve these notices on the first day that the tenant is late. So let's say the landlord gives the tenants 5 days. Technically, they're not late. And then the tenant tells the landlord that, oh, they mailed it already. That's another couple days. After that, serving the 14-day notice, it's already 1 month before the landlord can even bring this to the court. And then with all the scheduling issues, that's why evictions take forever in New York State. But yeah, it's to be expected. New York State is a very tenant-friendly state. But one thing I wish they would do is help the landlords in some way against the banks. Because most landlords aren't just sitting on the beach sipping their margaritas. They take checks in with one hand and then a couple days later they give it to the banks. So if a tenant isn't paying anymore, so even if the tenant stops paying and needs to be evicted, the landlord still needs to pay the bank. The Department of State should do something about that. Like if a landlord is in court with a tenant, then they should delay their mortgage payments. That would help, right? But yeah, I'm getting sidetracked. That has nothing to do with the agents. Anyway, I'm looking forward to seeing how this unfolds. I guess we won't see mass rent increases just yet in the city.